Is that my motion, a motion that I did, or did someone else do that?
I don't
Because
know.
I can
It's the
send it back
motion
in. I
you,
can send proof back in.
ma'am, if you keep interrupting me, because I'm about done. Here, Morris. This is her motion to set aside default.
It is indeed. And we did file
I'm here, Judge. I'm sorry. I couldn't get my phone on to work.
All right. That's her. Oh, there you are. Hello. State your name.
Here, Morris.
All right. This is your request to set aside the default.
Yes, sir.
All right. And what's the basis? You said you were unaware of the hearing.
No, so I was aware of the hearing. I was available for the first hearing. The attorney's office reached out to me and let me know that the staff needed some to be trained and that they were looking to resolve. So I had to keep reaching out, and nobody reached out to try to come to a resolve. So when the court date did come up, I just couldn't get back in time because I am working a contract with veterans in Las Vegas right now. So that is the reason why that I could not make it. I do believe my Zoom hearing was denied. So that's why I need to file a motion to actually be here.
Okay. Have the funds been paid to the landlord?
So that was the situation for the court date. Just in agreement of what funds they're saying are owed is not accurate.
Okay. I took a judgment, or a judgment was taken in November for 1,571.06. You're saying you don't owe that amount?
Yes, sir. That judgment was the day that I was not there. So we were supposed to try to come to a resolve. The issue actually stemmed from May. And Rachel Dornbush, I did speak with her on the issue in May. She did try to correct some things that we did not come to an agreement. There was a court date scheduled for May 16th, but somehow that was dismissed. But even on the Arbor Woods paperwork, they still had down that I had a balance. So we still should have been in court. So that is, I guess they didn't communicate that with their attorney because this is like all the way from May. So this issue has never been taken care of.
Your Honor,
Dornbush?
well,
Yes.
I'm looking at the ledger, and the reason that the case was dismissed is because there was a balance. I mean, there was a credit. I mean, there was nothing due and owing. So the case was dismissed for that reason. Your Honor, first and foremost, I mean, I'm going to object to the motion even proceeding because none of that was stated in the motion. The motion says I was unaware of the hearing. If there was something more that needed to be addressed as a part of this motion, Ms. Moore should have included that in the motion instead of making a false statement alleging that she was unaware of the hearing. That is verbatim what her motion says. I was unaware of the hearing, and this was only filed beyond 10 days because of the holiday. Well, if she was aware of the hearing, then she could have filed her motion on November 19th, November 20th. She could have filed it long before the holiday occurred, which prevented her allegedly from getting to the court to do it. So I'm going to object, Your Honor, that this motion hearing even moves forward on that basis. And I am going to request actual attorney's fees because the motion that was filed is clearly erroneous and a false statement was made to the court.
I actually did file more than one motion. The motion that I did file for the Zoom hearing, it was actually denied. So I did have to file another motion. And I did speak with two representatives at the court. One of the girls' name was Ashley, and they did let me know that I did have that time to. I actually sent a paper and I took a scan of it, and I sent that in with the explanation of what was going on with the case. So I think you may have read it incorrectly. I can pull it up and I can read it to you now. But the only reason why I was not there is because we were supposed to come to a resolve and no one ever reached out. And Rachel Dornbush, when you're speaking on it was a zero balance, if you check back onto your attorney's documents, onto your client's documents on the ledger, the same day that I spoke with you, you and you put that credit onto my account and we did not agree on my rental rate, they went back and put a non-sufficient funds fee there. So on the same day, there was definitely a balance and we should have been in court on the 16th. They didn't communicate that with you. My
Well,
rent was supposed to go
first
up
of all,
in August. I'm sorry.
there was, so, and I'm just to try to get the order of this, and I don't know if you've got this, Ms. Dornbush, there was, so what I have is exactly what you stated on the motion. On her request for a Zoom hearing, she just had indicated that she's currently working out of the state of Las Vegas. I was hoping to come and resolve, but I have not received a call back yet. I can get a flight after work, but I'd be late for court. Please allow me to appear via Zoom. There's a 3-hour time difference.
And so I believe that was in the Zoom request, Your Honor, that was submitted to the court the day before the hearing on, I think, November 17th at around 3:30 p.m., which was after she contacted our office on the same day. She contacted our office around 3 p.m. and was reminded of the in-person bench trial scheduled for the 18th. But her motion that was filed with the court says, I was unaware of the hearing and it's only after 10 days because of the holiday. That is false. Ms.
That's
Moore was
absolutely not true,
100% aware of the hearing.
If we're speaking on things, I'm sorry, my phone blanked out. If that may have been, I did file 2 motions. So I don't know if both of them actually it came through. I can't pull up the ones that I have and I can send it back into the court.
Ma'am,
So
I have your signature
mhm.
on a motion to set aside the default. And under paragraph 2, you're asking the court to set aside the judgment. And it indicates that it must be filed within 10 days of the default judgment. And then it's because, and you wrote in, I was unaware of the hearing, and it's only after 10 days because of the holiday. The first part of that is it's patently false. You were aware of the hearing because you filed the request for a Zoom on that, so you knew the hearing was taking place. And then you said it's after 10 days because of the holiday. I don't even get that because the judgment was on November 18th, and there's at least really 7 days, well, more than 7 days before the holiday. There was like 9 days before the holiday that you could have filed it. So,
and I'm
it did
confused
not
on the
get filed.
motion.
It
Go
did
ahead.
not get filed with us until December 1st was your signature, and that's when our timestamp is.
And yes, I do.
So,
I'm not trying to cut you off. I did call in. She did let me know that I had a few more days, and she let me know that I had to file a motion. I have the emails from you guys, and I never got the $20, I guess the check thing to actually put the motion in online. So I had to have someone come up there and do it. I would have had the motion in prior to that. My Zoom hearing was denied, and I did submit a piece of paper with a lengthy information on what we're talking about. This is the same conversation that we had prior to when the other attorney decided that they needed to train staff and we're trying to come to a resolve. So my information hasn't changed and my issue hasn't changed either. And if we would have been in court in May, because that ledger says I
in
had a
May,
balance.
ma'am, trying to go back to May, Ms. Dornbush just stated you had a credit on your account, and that's why they dismissed it.
Correct, the same day, Judge. Ms. Dornbush is not acknowledging that her client put a non-sufficient funds fee and reversed that payment back onto my ledger after I spoke with her.
When are you saying that happened?
That happened on the same day on 5/6 of
Do
2025.
you see that on the account, Ms.
I
Dornbush?
am, I do see that, Your Honor, and I believe, but I can't speak to it with certainty because I was unaware of that until Miss Morris brought that up. But if a dismissal had already been submitted to the court, my client would have then had to motion the court to reinstate the case, number one, to try
Right.
to pursue those amounts. And following that, Ms. Morris did continue to make payments on the account in June. Payments were made and credits were done to the account, leaving a balance of $50.49. And so I don't believe my client felt there was a reason to reinstate based on subsequent payments being made.
Well,
I mean,
sorry, I don't want to cut you off. Just to let you know, Ms. Dornbush, because I know you didn't speak to your client. I spoke to them and we were going back and forth. They ignored my phone calls, a whole lot of things. That was done probably about 2 hours after me and you had spoke. And they literally have it on the ledger. They knew about it and it took over 30 days for them to actually correct that. And they also put a $30 late fee onto May's rent as well. So this is an issue that needed to be addressed because just like with the $2, my rent was supposed to go up in August. That's a whole 12 months. So I understand that
what is her
they didn't.
current balance?
the current balance, Your Honor, hold on. I've got to find the current ledger that I have for this case. Give me just one moment. With December, Your Honor, $2,364.19.
And ma'am, if I take everything that you're saying, how much are you saying you owe?
Honestly, Judge, there was a discrepancy in
I know
September.
that.
Okay, I'm
So
saying in
you tell
September.
me,
Yeah, yes.
taking out all of that, how
Mm-hmm.
much do you think you owe right now?
I think I owe them around $300 from the discrepancy that the office made in September, sending out a notice, 7-day notice, saying that my rent was owed was
Did you
$360 and
pay
6 cents.
December rent?
Yes, I did. I paid it into escrow at the court, and I did that with November's rent as
Okay,
well.
I've got 700. So you're
My
saying that if I take that 700 off, add the 300, so basically $1,000, that you're saying that there's an error on your account in the amount of $1,364.19.
Yes, it is.
Absolutely not, Your
You
Honor.
can say
Where
absolutely not
where
if you
is
look at
that
the
gonna
first.
come from, ma'am?
So where it's coming from is my lease is supposed to start in August. They charged me a lease increase in May, June, and July. My lease is supposed to be from 8/1/2024
All
to
right, so in May, June, and July, what are you saying they charged?
they charged me $694 for lot rent.
And if you're saying that, what should it have been?
My lot rent should have been $657.
So that's about a $50 difference each of those months. That's $150.
On top of late fees.
So how many late fees?
They charge you two late fees per month.
Okay,
So
so
that's
even if they did
$85 per
that,
month.
and Ms. Dornbush, maximum amount of late fees per month is what?
Your Honor, the late fees total per month is 55 that gets charged on after the 5th and $30 that gets charged on the 21st. So it's $85 a month. However, let me go look at Miss Morris's ledger and see if she's actually making these payments timely. Because if she's not making her payments timely, whether there's a discrepancy or not, the late fee would have hit.
Okay,
So
I hear you on that. But what I'm getting at is your numbers aren't matching, because even if I take 85, give me 85 times 3, give me 85 times 4.
5 times 4, 340.
340. So I've got 150 and 340. Where else are you claiming that there's a discrepancy of some type?
Okay, so moving forward, if you look at to July, well, you took that. If you said my rent was $657 in July, I went into the office. They locked my mailbox, and I have been kicked out of the customer portal to pay online. So I get charged a $10 fee with every payment.
Ma'am, Listen to me.
If you look on my
Listen
ledger,
to me. You are claiming that there is some $1,300, almost $1,400. That is a discrepancy on your account. I'm
yes,
asking
sir.
you for where that discrepancy is.
Okay,
You
sir,
are
and
giving me 150. I'm not
sir.
agreeing with you. I'm just saying, where
Mhm.
are you getting these numbers?
So where I'm getting these numbers from are my ledger. It started in May. So they put a non-sufficient funds fee on the account. After they put that non-sufficient funds fee, they added that money that was owed for May, the rent, they added that onto June. I have a 7-day notice from June. It says my rent at the top of the paper is $657, but they're not putting that onto the ledger. So that is incurring a balance. They put the non-sufficient funds fee, put the 718 back onto my ledger around June 12th or June 13th. Moving forward, we still had a balance in July. No one is trying to come to an agreement about the balance with my ledger. So it kept on incurring. Then we get to August. August, I go into the office. They say I owe $175. So she says, well, you know what? Since you've been locked out of your account, her name is Dana. She said, you've been locked out of your account. We'll credit you those $10 fees back. I'll do 17 of them. We're going to investigate. We'll do more. Kenya just took those $170 credits off in October. Those were supposed to be taken off in August. I paid my October rent to the office. They told the court that they didn't have any rent. If you look at 9/6 on my 7-day notice, Kenya, the new manager, sent out she sent out a letter saying I owe $360.
Ma'am, you are telling me that there's some $1,300, $1,400. You are not telling me where those numbers are coming from. You
Okay,
have
so let me
given
rephrase
me
this,
a
Judge.
total amount of $490, basically, that you're saying shouldn't be on your account.
I said there's a total, the $450, if you look at my ledger that I paid in September, that was supposed to be the total balance owing for September. That was a staff error. It was $360. I made a $450 payment to cover the late fees. So I should not have a balance. That was a staff error, not my fault. They sent me one paper in the mail and they sent another paper to the court. They also tried to steal my money order. I also submitted to the court the payments that are made on their check system. My money order from May is not in that check system. Kenya, the manager, asked me, well, did they actually put it back into the check system? I said, I don't know. So I asked her, could I have proof? So all of this, my account is screwed up since May because of these different charges. They're saying I owe $2,000, but they also charged me a late fee and my rent was in escrow in November. My rent was paid to the office. The only time my rent was short was in September of 2025. And that was a staff office error. That was not a tenant error. I paid what they said was owed. Then they turn around the same day and send the court the same paper with different numbers on it. That's not my fault. All of their information that they even sent into the court with my lot rent. Sometimes it's $266, sometimes it's $391. And Rachel Dornbus, you or the rest of your colleagues never addresses it. They started my lease last year in 2024 in July. It was
All right,
supposed to start in August.
ma'am, here's the problem. Problem is, your motion says none of this.
Is that my motion, a motion that I did, or did someone else do that?
I don't know.
Because I can send it back in. I can send proof back in.
Ma'am, you know, if you keep interrupting me, because I'm about done. You're not answering my question. You're not giving me the figures. You gave me some figures which amount to 490, but that doesn't even make any sense to me.
Okay. My question is, how does it not make sense from me, but it makes sense from the attorney? You're being biased.
I'm done. You're not
You're
going to
biased.
interrupt me.
You're very biased.
You're not gonna keep interrupting me. Motion
Sorry,
denied.
I was never trying to interrupt you. You're very biased.
Writ may issue. Thank you.
You're very biased and disrespectful.
I'm done.
It doesn't matter. You're disrespectful and you're very biased. You need to do your job. You don't know how to do your job. That's all.
Her. I am done. Motion denied.
Your Honor, I would request that the money's held in escrow. I think, Your Honor.
The monies held in escrow are released to plaintiff and will be applied to the account balance.
Thank you, Your Honor.
You have an attorney, you have a boss as well. You're
Coach-
very biased, rude,
Coach,
and
you just-
disrespectful.
Mute her and kick her out of the meeting.
James Cedric on behalf of Ms. Williams, that's Matt Keys. I don't know if he has to be here.
Oh, we have to get Mr. Keys up. Mr. Keys, we just went on, I just called the case. Can I get your appearance?
Matt Keys on behalf of probation.
All right, it's time and date. So,
James Cedric on behalf of Ms. Williams,
Thank you.
President Court. Ms. Williams had the opportunity to go over her constitutional rights, that has no questions. She's going to enter a plea of guilty to the charge with an explanation, Your Honor.
okay. Ma'am, did you understand everything your attorney just said?
Yes,
All right, and did you go over this probation violation advice and rights form with your attorney?
yes,
Did you understand your rights?
yes,
And did you sign the back?
yes, I do.
Ma'am, you understand that if you enter a plea of guilty, you'll be waiving the rights on this form. You understand that?
Yes,
Okay, and is it your desire to waive those rights after talking to your attorney?
Yes.
Okay, so there will be no hearing if you enter a plea?
Yes.
Okay. Knowing all of that, this is a second technical violation. I could give you up to 10 days jail. Do you understand that?
yes,
All right, knowing all of that, to the allegation you tested positive for alcohol on November 27th, how do you plead?
guilty.
Has anyone forced you, threatened you, or promised you anything to get you to plead?
No,
Are you pleading guilty of your own free will?
yes,
Okay. All right, I'll accept the plea as knowing and voluntarily given. And Mr. Gazicki, and Ms. Williams, before you give me your explanation, I just want to say I am not an idiot. And if you give me an idiotic why, I'm not going to appreciate it. I have a treatment court here. I have heard everything under the sun that you could possibly come up with. And you get a lot further with me if you tell the truth than if you lie. So I'm letting you know that ahead of time. What would you like to tell the court, Mr. Gazicki or your client?
Your Honor, that's what she consumed, non-alcoholic beverage.
Okay,
And she
that's
had
what
to
she's
put
going
you-
with? Okay, good. No, I like that. Good. Go ahead, Mr.
No,
Gazicki.
that's it.
Tell me more. That's it?
No, that's it, Your Honor.
Okay, well, that's fascinating, and I've never heard that explanation before. This is the first time someone's tried that on me. Mr. Keys, you have anything to say?
Yeah, the
Second alcohol violation.
correct, on an operating while intoxicated.
With a .24, right?
You know, I mean, at the end of the day, whether it was alcohol, a beer, a non-alcoholic beer, I mean,
Mr.
non-alcoholic beers, almost all of them actually contain alcohol, so
Mr.
there's
Keys.
no way that we'd be able to determine.
No, Mr. Keys, how much alcohol does a non-alcohol, like, let me give you just a hypothetical.
If I.
Okay, so how many would you have to drink, do you think? And I'm not good at math, everybody knows that, but how many do you think you would have to drink to get 1, 2, 3, 4, 5, 6, 7, 8 times the cutoff?
I don't think I could put a value on it, but I think it
Do
would
you
have to
think
be quite a few.
Yeah, it might be 100, I don't know, for you to get, did you have 100 non-alcoholic beers or 30 in one sitting?
no,
You're very small. So the cutoff is 500 for it to even test positive. So people could probably have or get away with a non-alcoholic beer or two and come in and still test negative, right? It's such a low alcohol content. And for you to come in at 4,000 nanograms per milliliter, you would have had to have drank. And I don't know, I can get on Google and find out how many you would have had to drink, but it would be a mountain of non-alcoholic beers. So I think you're lying. So now, instead of me following the recommendation of Mr. Keys, you had a .24. And then when you got stopped, you were 3 times the legal limit. So that time, I don't know, you must have had 20, 50,000 non-alcoholic beers. And then you've already had 1 alcohol violation. And now this is your second one. And the first one, I tried to give you therapeutic recommendations. You understand you get up to 10 days jail today? Do you understand that?
I do understand.
Okay, so listen, I am tired. I am tired of hearing nonsense. And I told you before you told me your lie that you had choices. You could tell me the truth and come clean and I'll adopt the recommendation. We'll be good to go. Or you can lie to me. And you made that choice. And there's a consequence for that. Because I don't believe for 1 minute, not even, I want you to understand the level of belief I have in what you just told me is negative. Like it's nonsense. And everybody in here knows it. You came in at 4,000 nanograms per milliliter. 5 days jail, immediate, forthwith. You're not drinking on probation.
I'm not.
Okay, well, you're not now, at least for the next 5 days, you're not.
Court does call the case of the people versus Daniel Cummings.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Cummings, who is approaching.
Your name, sir?
Daniel Cummings, Judge, Your Honor.
Your Honor, I do have a green sheet. We are requesting an adjournment. We are going to refer Mr. Cummings to a Veterans Treatment Court. He does live out of county, so
Gonna take a minute.
Redford.
Would you be able to get that accomplished by the 30th, or you need more time than that?
Thank you.
Well,
We can try. See where we can get.
Probable cause conference will be adjourned to December 30th, 2025, 9 a.m. Bond will continue.
Your Honor, Mr. Cummings would like me to address bond.
Briefly,
Your Honor, Mr. Cummings is requesting a personal bond. He is currently in custody with significant medical issues. As you can see, he wears a brace. He has to wear that 24 hours a day. He about a year ago received a back surgery with that involves getting 14 rods in his back. He has to sleep in a certain type of bed, which obviously is not available here in the jail. He also has cystic fibrosis, so he has to wear a vest to shake his lungs. He cannot use that in the jail. He also uses a nebulizer, but he cannot use that in the jail. He's on about 18 different medications, and he cannot receive most of them while in
Shot every day
custody.
for my bone deterioration
His osteoporosis, he says he receives a shot
every day.
every day, cannot receive that in the jail. So these things are accumulating. He is relying on one lung to breathe as one of his lungs is collapsed. So he's really struggling.
that doesn't account
medically.
for his fentanyl use, does it?
No, it doesn't, Your Honor, but
I know, and that's the reason that you're in and why I revoked your bond. You
right.
can continue, Ms. Perrini, briefly.
You know, I think Mr. Cummings, this is his first offense, his first time being on bond, his first time ever drug testing, doing anything like this. I think he's really learned potential consequences of his actions. He's been incredibly remorseful to me every time we've spoken, and I think he's incredibly willing to commit to any bond conditions the court may order. He's discussed testing every day and home confinement. He really wants to get home to his wife who has Alzheimer's. He's just really struggling.
May I say something, Judge? Please. I like to address, I want to say thank you for locking me up. It allowed me to get off of drugs, and I feel my mind is clear, my body's clear. I feel fine. I have no urge to, this kind of place is not for me. I've never been, don't have a criminal record. I've never been in jail. Only thing I did, well, you know what I did, and I just need to get home to my wife and my medicines. Otherwise I've had MRSA, I've had pneumonia, but that's what's happening. And I need to lay in a certain bed, an incline bed, or my surgery is not going to hold. I got 13 bars in my back, and I will do anything
I'm
and
sure
everything.
out to the jail medical personnel, they'll accommodate you in the best way that they possibly can.
They said they can't give me these medicines. can I be under a house arrest?
Anything else?
Um,
This isn't a negotiation, but anything else?
you mean I have to stay in jail?
Anything else?
I'm not sure what's going on.
I've listened to you. Counsel, I've listened to you.
I'm gonna end up getting sick in here, sir. And can I just be under house arrest? I won't go nowhere.
Sir, we gave you bond conditions. You violated those bond conditions. I revoked your bond because of that. There isn't a medical reason for those drugs that were in your system. You shouldn't have been using them anyway if you suffer from as much as you suffer from at this point in time. And so.
Well, I was addicted, and when they said come in for the Washtenaw corrections, come even if you're dirty, and then we'll help you detox. Okay. All right. Well,
I don't need a response. If people motion for bond reduction is denied, bond will continue as revoked. Thank you. Court does call the case of the people versus Edward Byrne.